The breathing dead. The logbook entry for 2:40 p.m. reads, "Procedure halted. For 2 hours, the needle had entered skin 18 separate times, and 18 times it had failed to find a vein. The man on the gurney, legally condemned and now declared unexecutable by the warden, was still breathing." The logbook entry for 2:40 p.m. reads, "Procedure halted. For 2 hours, the needle had entered skin 18 separate times, and 18 times it had failed to find a viable intravenous line. The man on the gurney, Michael Vance, legally condemned and now declared unexecutable by the warden, is still breathing." The record begins at 13:31. The execution team enters the chamber at the Southern Ohio Correctional Facility in Lucasville, Ohio. The air is sterile, conditioned. The log notes the time, the personnel present, and the opening of the intravenous kit. Michael Vance is strapped to the gurney, his arms extended. Entry 1335. First attempt, left antecubital fossa, a 22-gauge catheter. The log notes the site is prepped with an alcohol wipe. The needle is inserted. The vein rolls away from the point. The attempt is abandoned. Entry 1342. Second attempt, left forearm. The log describes the skin as scarred. The veins difficult to palpate. Another insertion. A flash of blood is reported in the catheter hub, but the vein collapses upon the attempt to flush it with saline. A small hematoma begins to form under the skin. Minutes pass. The document records a change in strategy. The team moves to the right arm. The process repeats. Insertion, failure, withdrawal, wipe. The paper trail is a rhythm of methodical failure. The log is dispassionate, its language clinical. It does not record the sound of the heart monitor or the shifting of feet on the tile floor. It only records the procedure. The search migrates from arms to hands. The log notes Vance's attempts to assist, clenching and unclenching his fists as directed. Entry 1405. Attempt 9, dorsal side of the right hand. The technician reports a collapsed vessel. The inmate is noted to grimace. His vocalizations are not transcribed. Warden Andrew Thomas observes from behind the glass, his presence noted in the initial log entry. The SATE's protocol is specific. The death warrant, signed and dated, carries a temporal limit. It expires. The clock on the chamber wall is an instrument of compliance. The room itself holds a quiet history of malfunction. The institutional memory contains names not written in this logbook. Ron Broom, Doyle Lee Han. Precedents of procedural breakdown within these same walls in Ohio. Entry 1420. The team makes attempts on Vance's lower legs, ankles. The log notes his history of intravenous drug use, a factor cited as contributing to the degraded state of his veins. Each puncture leaves a mark, a small, dark testament to the effort. The record continues its monotone tabulation. Attempt 15. Attempt 16. The same result is copied and pasted by implication. Site prepped, needle inserted, vein compromised. By 1440, the lead technician looks toward the warden. The log records a brief verbal conference. The warden consults the protocol book. The 2-hour mark has passed. The warden makes a decision, not of mercy, but of compliance. He gives the order. The final entry is stark. It cites a failure to establish intravenous access within the allotted time frame. A new document is generated, a transfer order. It directs that inmate Michael Vance be unstrapped from the gurney. It directs that he be escorted from the execution chamber and returned to his holding cell on death row. The logbook is closed. The warrant remains unfulfilled. The apparatus arrives in St. Martinville, Louisiana, on the back of a flatbed truck. The engineering report, filed post-event, identifies it as a portable oak chair with leather straps and a headpiece containing a saline-soaked sponge. Local journalism has already given it a name, Brucem Gertie. It is the state's new instrument, designed to travel from parish to parish, delivering a sentence codified in voltage and amperage. Its first subject is Samuel Jones. Witness affidavits, taken in the hours that follow, provide a discordant record of the setup. 3 separate statements note the unsteady gait and slurred speech of the 2-man team responsible for assembling the chair and connecting it to the FCF. Portable generator. An engineering report later confirms their error. A critical wire meant to ground the current is connected improperly, a mistake that will render the full electrical charge undeliverable. No pre-execution test is performed. The documentation shows no checklist was signed. At the appointed time, Samuel Jones is strapped into the chair. His head is shaved. The straps are tightened over his chest, arms, and legs. A witness, a priest, makes a sworn statement that the inmate attempted to speak, but the leather-lined headpiece is secured before he can form words. The switch is thrown. The lights in the small brick room dim. A low hum emanates from the generator outside. According to 4 of the 5 official witnesses, the body of Samuel Jones strains against its restraints. The convulsions are violent, but brief. Two affidavits record a muffled shout, transcribed as, "Take it off." One witness reports the smell of burning fabric. Then, silence. The hum from the generator cuts out. The lights flicker and return to full brightness. Samuel Jones is slumped in the chair, breathing. He is alive. The captain of the guard's report describes a scene of confusion. The executioners check the generator, their movements now frantic. The attending physician confirms the inmate has a pulse. He is unstrapped and carried, half-conscious, back to his cell. The procedure is a failure. Within 24 hours, a new document enters the official record. It is an emergency motion filed by defense attorney Patrick Cunningham. The legal language is cold, precise, and urgent. It argues that the state of Louisiana has now carried out its sentence, however flawed the execution. To subject Samuel Jones to the apparatus a second time, the motion contends, would not be the fulfillment of a sentence, but a separate, unconstitutional act of torture, a violation of the 8th Amendment. The state's response is immediate. They declare their intent to repair the chair and schedule a new date. Cunningham's filing anticipates this, referencing a near-identical case that unfolded in the same parish of St. Martinville less than 2 years prior. On May 3, 1946, a teenager named Willie Francis survived this exact chair due to this exact error. The United States Supreme Court, in Francis v. Resweber, ruled on May 9, 1947, that a second attempt did not constitute double jeopardy. The precedent hangs over the new case file. The legal battle has begun, but the outcome feels predetermined by a decision already made. The public record for London, England, dated November 24, 1740, lists Thomas Green for public execution at Tyburn Hill. The charge is the rape and murder of Sarah Griffin. The sentence is death by hanging. The day is cold. The crowd is a fixture, a required audience for the spectacle of justice. The cart carrying the condemned makes its slow progress through the streets. At the gallows, the procedure is routine. The hangman adjusts the rope. A hood is placed over Green's head. The cart is pulled away. The body drops. The record notes it hangs for the prescribed 15 minutes, a duration deemed sufficient to ensure death. There is no struggle noted in the executioner's log. The body is declared dead by the attending sheriff. The sentence, however, has a second part. As is customary for such crimes, the body of the executed is forfeit to the Company of Barber Surgeons for public dissection. It is a post-mortem continuation of punishment, a denial of a proper burial. The corpse is cut down from the Tyburn gallows and transported by cart to the surgeon's hall. Inside, the room is cold, lit by candles. The body of Thomas Green is laid out on a wooden table. The minutes from the college proceedings detail the scene. A senior surgeon and his apprentices gather. Scalpels and saws are arranged on a tray. The purpose is anatomical study. The dissection is set to begin. The senior surgeon's assistant makes the first observation, a faint, rhythmic motion beneath the sternum. It is at first dismissed as a post-mortem spasm, a twitch of cooling muscle. But it continues. The lead surgeon places a hand on the chest of the corpse and feels it. The unmistakable, shallow rise and fall of a lung filling with air. A low groan escapes the subject's throat. The record book shifts in tone. The clinical language of anatomy gives way to urgent, active verbs. The surgeons abandon their instruments. They begin revival efforts. They force water between his lips. They perform a letting of blood, believing it will restore circulation. They rub his limbs with blankets to restore warmth. After several minutes of this work, the man on the table opens his eyes. Thomas Green is alive. The surgeons, who moments before were prepared to dismember a corpse, now find themselves attending to a patient. A man has fulfilled the legal requirement of his own execution. The authorities are summoned. The news spreads through London in broadsheets and whispers. A petition is drawn and sent to the Crown. It does not argue innocence. It argues a point of law and fate. The sentence, to be hanged by the neck until dead, was carried out. The state's process was completed. That the man survived is not a failure of the law, but an event outside of its jurisdiction. The public sentiment, recorded in pamphlets of the day, frames it as an act of providence. The Crown responds. A royal pardon is issued. The legal reasoning is simple. The sentence has been served. The King's justice does not require a second attempt. Thomas Green's death sentence is commuted to transportation for life. He is a man who walked through his own death and emerged on the other side, bearing a pardon from a law that had no other way to account for him. The entry in the college logbook ends. The body, once a subject for dissection, is now a living man awaiting a ship. There is no court filing from this event. No warden's logbook. No petition to a crown. The only official record of the execution of Miguel Reyes is a photograph, taken years after the fact. It shows a man staring directly into the camera. One eye is gone, the socket a hollow shadow. A deep, jagged scar runs from his jawbone up into his temple, pulling the corner of his mouth into a permanent grimace. This photograph is the only document. The rest is reconstructed from his own account, later transcribed by journalists covering the aftermath of the revolution in Mexico. The year is 1915. The forces of Venustiano Carranza control the territory. Miguel Reyes is a soldier on the losing side. In a time of summary justice, accusation is the same as conviction. There is no trial. He is dragged from a holding cell at dawn and marched into a dusty courtyard. The wall behind him is already pockmarked from previous sentences carried out. 9 soldiers form the firing squad. The order is shouted. The rifles, held without precision, discharge in a ragged volley. The later account, his account, describes the impact of the bullets not as sharp pains, but as a series of heavy, concussive blows. He is thrown backward against the wall and slides to the ground. The world goes dark. A final procedural step remains. The officer in charge of the squad draws his pistol to administer the coup de grace, the mercy shot intended to end any suffering and guarantee death. He steps over the bodies of the other condemned. He stands over Miguel Reyes, places the barrel of the pistol against his lower jaw, and fires. The body jerks. The officer holsters his weapon. The squad marches away. The task is complete. The bodies are left for later burial. But the task is not complete. Hours pass. The sun climbs higher. According to his testimony, consciousness returns not as a thought, but as a feeling. The intense heat of the sun on his face, the taste of blood and dust in his mouth. He opens his one remaining eye. He is surrounded by the dead. He moves a hand, then an arm. He pushes himself up from the ground, the world a blur of pain and light. He begins to crawl. His account does not specify for how long or how far. It only records the single-minded effort to move away from the wall, away from the place of his own death. He is eventually found, taken in, and nursed back to a state of improbable health. The photograph serves as the final report. The bullet from the coup de grace shattered his jaw and exited through his eye socket, but it did not kill him. It remained a piece of metal lodged in his skull that he would carry for the rest of his life. His own scarred face becomes the affidavit. His survival becomes the undeniable record of a state's failure, a sentence carried out by 9 rivals and a pistol that still failed to be final. The event itself is not the subject of this file. The failed attempt on the life of David Chen in Alabama is a closed matter, a 2.5-hour ordeal documented in a separate, sealed execution log. This narrative is built from the paper that grew in its aftermath. A decade of motions, appeals, petitions, and evaluations that constitute a second, more protracted procedure. The file begins with a petition for a permanent stay of execution. Its central legal argument rests on two clauses in the Eighth Amendment to the Constitution: cruel and unusual punishment. The initial filing argues that the state, having subjected the inmate to the complete process of an execution, the final preparations, the strapping to the gurney, the prolonged and painful search for a viable vein, has, in effect, carried out a punishment. To force him to undergo the ordeal a second time would be to punish him again for the same crime, with the added psychological torment of knowing precisely the failure that awaits. The document contends this constitutes a new and distinct form of cruelty, unforeseen by the original sentencing court. The state of Alabama's response is a counter-motion to dismiss. The legal reasoning is direct and procedural. The court's sentence was death. The inmate is not dead. Therefore, the sentence has not been carried out. The state's brief characterizes the initial failed attempt as a technical complication, an unfortunate but unintentional administrative issue. It is not, the state argues, a form of punishment in itself, but merely a delay in the administration of the legally mandated punishment. The state's argument is built upon a legal foundation established decades earlier. It cites the precedent of Francis v. Resbeaver, the case of Willie Francis, who survived the electric chair in Louisiana. In that ruling, the United States Supreme Court determined that a second attempt did not violate the Constitution. The majority opinion held that the cruelty was not in the second application of electricity, but only in the deliberate, malicious infliction of pain. An accident, however gruesome, did not qualify. This precedent, first invoked in the case of Samuel Jones, now becomes the primary legal obstacle for David Chen. Chen's legal team spends years trying to dismantle this precedent. Their filings argue that the legal and medical landscape has changed. They introduce the cases of Ron Broom and Doyle Lee Ham in Ohio and Alabama, respectively, as evidence of a systemic problem with lethal injection, not an isolated accident, as with the electric chair. They argue the prolonged conscious suffering during these modern failures is fundamentally different from the brief malfunction that spared Willie Francis. The file thickens. Years are marked not by seasons, but by the filing dates on new documents. Year 3. A court-ordered psychological evaluation is entered into evidence. A state-appointed psychiatrist documents his findings in clinical, detached language. Excerpts. Note the inmate exhibits symptoms consistent with severe trauma, chronic hypervigilance, intrusive re-experiencing of the event, and a persistent state of anticipatory anxiety. The report concludes that the inmate's psychological condition has significantly deteriorated as a direct result of the failed execution and the subsequent legal uncertainty. The defense files this as proof of ongoing state-inflicted punishment. Year 6. The 11th Circuit Court of Appeals denies Chen's appeal. The majority opinion, a dense 20-page document, reaffirms the precedent of Francis v. Resweber. It states that, while the circumstances are regrettable, the court is bound by precedent. The intent of the state was to execute, not to torture. The failure of the procedure does not nullify the legality of the sentence. Year 10. The final document in the legal battle is a petition for a writ of certiorari, filed with the United States Supreme Court. It is a last resort. The petition consolidates a decade of arguments into a single, direct question: does a state's second attempt to execute a prisoner, after a prior attempt involving hours of physical pain and resulting in documented, long-term psychological trauma, violate the evolving standards of decency that mark the progress of a maturing society, and thereby constitute cruel and unusual punishment under the Eighth Amendment? The response from the court is not an opinion or a judgment. It is a single line on an order list: certiorari denied. The highest court declines to hear the case. It offers no explanation. With that one line, a decade of legal maneuvering is nullified. The precedent of Francis v. Resweber stands. The Eighth Amendment question, for David Chen, remains unanswered by the only authority that could have provided a definitive resolution. The file is closed. The state of Alabama is now legally clear to set a new date. In this case, there is no malfunction of a machine, no miscalculation of current, no collapsed vein, no rope that fails to break a neck. The failure is in the process itself, a mechanism of bureaucracy that starts, stops, and restarts with the dispassionate rhythm of a ticking clock. The subject is Robert Evans. The jurisdiction is Texas. The record is a collection of warrants and their rescissions. File 1. Death Warrant 1. The document is signed by a state judge. It sets a date and a time, 6 months from its issuance. In the weeks leading up to the appointed day, the prison logs for Robert Evans show a pattern of procedural finality. A final meal request is recorded and approved. A schedule for the final family visit is logged. On the day of the execution, he is moved from his cell on death row to a small holding cell adjacent to the execution chamber. The clock moves toward the designated hour. At 4:37 p.m., less than 2 hours before the sentence is to be carried out, a fax arrives at the warden's office. It is a court-ordered stay of execution. The reason, cited in the attached legal brief, is administrative. The state's supply of pentobarbital, a key drug in its lethal injection protocol, has expired, and its European manufacturer refuses to sell more for this purpose. The execution cannot proceed as mandated by state law. A second document is generated, a rescission of the warrant. The prison log notes the time Robert Evans is returned to his cell on the main row. File 2. Death Warrant 2. 18 months pass. The state of Texas has secured a new supply of drugs from a compounding pharmacy. A new warrant is issued for Robert Evans. The cycle repeats. The date is set. The final meal request is filed, identical to the first. The family visit is logged. The transfer to the holding cell is recorded. Again, the clock moves toward the hour of execution. This time, the stay arrives at 5:02 p.m. The reason is a clerical error, discovered by an appellate lawyer during a final review. The original warrant, from which all subsequent orders are derived, lists the incorrect date of the original conviction. It is off by a single day. The error renders the entire legal foundation for this specific warrant invalid. The fax machine prints the stay. The rescission order is filed. The log records the return of Robert Evans from the holding cell. A prison medical log from the following week notes a request from the inmate for medication to treat insomnia. The request is granted. File 3. Death Warrant 3. 2 years pass. A corrected warrant is issued. The date is set. The logbooks document the now familiar ritual: the meal request, the visit, the short walk to the holding cell. The hours of waiting. During this period, a coalition of news organizations, including a journalist named Trina Middleton who has been following the case, files an emergency lawsuit against the Texas Department of Criminal Justice. The suit challenges the state's secrecy laws, which allow it to conceal the identity of its new drug supplier. The suit argues this secrecy prevents inmates from challenging the quality and efficacy of the drugs, a potential violation of the 8th Plant Amendment. A federal judge grants a temporary restraining order, halting all executions in Texas until the matter can be heard. The order arrives at the prison at 3:15 p.m. Another warrant is rescinded. Another entry is made in the prison transfer log. A note in Evans's medical file from this period describes a state of flattened affect and social withdrawal. File 4. Death Warrant 4. The lawsuit is resolved. The secrecy laws are upheld. A year later, the 4th warrant for Robert Evans is signed. For the 4th time, he makes his last meal request. For the 4th time, he has his final visit. For the 4th time, he is placed in the holding cell to await the hour. This time, there is no obvious legal challenge pending. No known clerical error. No reported shortage of drugs. The process appears to be final. An hour before the execution, the United States Supreme Court issues an unrelated order. It agrees to hear a case from another state that raises a new question about the intellectual capacity of a different inmate. As is standard practice, the court issues a temporary stay for any pending executions nationwide involving similar, even tangential, legal questions until their own case is resolved. The fax arrives. The warrant for Robert Evans, a man whose case has no connection to the one before the High Court, is stayed. It is then rescinded. The final entry in this file is the familiar log of his return to his cell, the paperwork of his death sentence once again rendered void by the paperwork of the system designed to carry it out. The cycle is complete and ready to begin again. The logbook entry closes, but the story does not. From the cold precision of an execution log to the chaos of a firing squad, the result is the same. A life scheduled to end persists. We began this record with a man on a gurney, still breathing, and we end with the quiet echo of that same breath across centuries of procedural failure. These are the moments that exist in the margins of the official record. Here at Half Criminal Records, we believe these accounts are a critical part of the historical archive. In the case of Thomas Green at Tyburn, the surgeon's decision to revive him led to a royal pardon. Do you believe their intervention was a medical duty to preserve life, or an interference with the sentence the law had already declared complete? Thank you for joining us for this examination of the archives. We will see you again soon. Next time, we will open the file on what happened when the state of Texas decided the fourth rescinded warrant would not be the last for Robert Evans.